Welcome back to the Constitution Line by Line. I'm Senator Mike Lee, and today we're continuing our discussion of Article 1, Section 8. This time we're going to focus entirely on one of the most important and heavily litigated clauses of the whole Constitution, that is, the Commerce Clause. The text gives Congress the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes, close quote. The first thing that jumps out about this clause is the word regulate. In modern America, we've grown accustomed to understanding regulation to mean rules or restrictions, but that's not necessarily how the founders would have thought about that word. In this context, the word simply means to keep regular. That is to say, to remove barriers and interruptions that would otherwise impair and impede trade between the states. The fact that we understand the word regulate in a very different way today has resulted in a whole lot of confusion surrounding the clause. You see, the goal of the Commerce Clause was to empower Congress to facilitate trade between the states, and conversely, to prohibit the states from engaging in economic balkanization of the sort that we saw under the Articles of Confederation before the Constitution was adopted. As we mentioned in the last episode, one of the biggest problems with the Articles of Confederation was that it was very difficult to conduct trade across state lines due to different laws and standards and tariffs set up by state governments, sometimes with the specific purpose of favoring commerce from their own state at the expense of commerce from other states. You see, the founders wanted the United States to function as a unified nation and a unified economy. Because of the Commerce Clause's broadness and vagueness, interpretations of what limits it might actually impose on Congress have differed over the years. And the clause continues to be the source of some legal controversy even to this day. While few dispute that Congress has the power to set the terms by which we deal with other nations, the phrase "to regulate commerce," when applied to the states, can be read in a number of different ways. From the very beginning, the idea that Congress should have only certain limited powers, and that the powers enjoyed by Congress should be only those specifically enumerated in the Constitution, was key to the drafting of the Constitution. It was also key to its ratification. In fact, I don't think it would have been either signed by those attending the convention or ratified by the states in the absence of that understanding. That understanding, which was implicit in the original text of the Constitution, was made even clearer a few years later by the adoption of the 10th Amendment. But the idea is that Congress has only a few powers, those that are made federal by the Constitution, and that in the absence of a power being specifically designated as federal by the Constitution, that power is retained by the states respectively, or by the people. The Commerce Clause has been used and manipulated to a significant degree by those who want to sort of undo that understanding, for those who want to see Congress doing more, for those who want Congress to have an almost open-ended regulatory authority. In the 21st century, it's difficult to identify many commercial activities that aren't in one way or another deemed subject by the federal courts as subject to Congress's authority under the Commerce Clause. Now, if we interpret the word regulate to mean the ability to legally prescribe certain behaviors, and if we also interpret the concept of interstate commerce to include any and every activity that, when measured in the aggregate, has a substantial effect on interstate commerce, then there would seem to be no significant limit to Congress's authority to regulate business affairs and economic activity generally. The narrowest way you can read the Commerce Clause is to say that it prohibits states from messing with interstate commerce, that they can't unduly burden or unreasonably interfere with interstate or foreign commerce. The Supreme Court has, in fact, embraced this view, but just embraced it non-exclusively, meaning they've said that the Congress has power beyond the authority to prohibit states from messing with interstate commerce, but it includes that power, and it includes it in a way that doesn't require Congress to act affirmatively to stop it. In other words, Congress certainly does have the power to enact legislation saying a state cannot mess with interstate or foreign commerce in the following ways, and here are the remedies by which that prohibition can be enforced. But even though Congress hasn't adopted that, the Supreme Court of the United States has, over time, interpreted the Commerce Clause as doing that, and we call this interpretation the so-called dormant Commerce Clause. That has a couple of permutations. Under one permutation, the more commonly accepted one, the Supreme Court has said that a state may not deliberately discriminate against an article of commerce based on its origin or destination, out of state or outside the United States, unless the state can show that this is the least intrusive means of achieving a legitimate, non-discriminatory objective. Basically, it gives the courts a way of making sure that states aren't deliberately engaging in economic balkanization by overtly favoring or disfavoring commerce based on its origin, out of state or outside the United States. The other permutation of the so-called dormant Commerce Clause deals with the incidental burdening of interstate commerce by an objectively neutral state law that is passed but ends up having the effect of messing with interstate commerce. Outside the dormant Commerce Clause, we look to the Supreme Court for guidance on what exactly it means and how far Congress's affirmative authority can extend. For most of the history of the Republic, most of the time under which we've operated under the Constitution of the United States, the Commerce Clause has been interpreted and understood to give Congress the power to regulate channels or instrumentalities of interstate commerce and interstate commercial transactions, and things like interstate airways, airwaves, waterways, and so forth, that Congress would have this power affirmatively. But since April 12, 1937, the Supreme Court has also interpreted the Commerce Clause to give Congress the power to regulate economic activity that, in the aggregate, even if the activity in question takes place in one state at one time, can be said to have a substantial effect on interstate commerce. That's deemed, and has been deemed since 1937, as within Congress's authority to regulate interstate commerce. Only 3 times since April 12, 1937, has the Supreme Court identified something that Congress has enacted as being outside of Congress's Commerce Clause authority. And of those 3, really only 2 of them count, because in the third instance, the Supreme Court went on to say that what Congress did could be justified under another provision of the Constitution. Many have criticized the way that the Supreme Court has interpreted the Commerce Clause in this respect as excessively broad, saying that there would have been no need for many of the other freestanding powers in Article 1, Section 8 if the Founding Fathers had understood, and had the public understood at the time of the drafting and ratification of the Constitution, that Congress would have the power to regulate any and every activity that, when measured in the aggregate, would have a substantial effect on interstate commerce. This was a view expressed at length in a concurring opinion in the 1995 decision of United States versus Lopez, in which the Supreme Court invalidated key provisions of the Gun-Free School Zones Act. One of the reasons why this matters, and one of the reasons why it's important for people to take into account critiques like those found in Justice Thomas's concurrence in United States versus Lopez, is that to the degree that any power of Congress is interpreted as being open-ended and unlimited, then it renders the 10th Amendment and the broader understanding of federalism found in the Constitution is sort of nugatory. It renders it dead letter. The fact is that the Founding Fathers, those who drafted the Constitution and those who were involved in its ratification, understood these words as creating only limited enumerated powers. They didn't understand any provision as providing an open-ended regulatory hook, as supplying general police powers to the federal sovereign. And if they had understood that at the time, had those words been understood in 1787 when they were drafted or throughout the ratification process as providing an open-ended source of virtually unlimited authority, then the Constitution would never have been agreed to at the convention, much less ratified by the requisite number of states. This is one of the reasons why I think this will continue to be an important issue before the Supreme Court of the United States. Because to the extent that the Commerce Clause gives the power to Congress to regulate anything and everything, then Congress's authority has ceased to be limited. Remember, James Madison described the powers of Congress in Federalist number 45 as being few and defined, and those powers reserved to the states as numerous and indefinite. In many respects, since 1937, we've flipped that concept on its head, specifically through the Commerce Clause, where Congress now has powers that could be described as numerous and indefinite. Thank you for joining me for this episode of the Constitution Line by Line. In the next episode, we're going to continue looking at Article 1, Section 8. We'll cover a number of other clauses, including those dealing with the power to coin money and regulate the value thereof, and Congress's authority to define the terms of intellectual property rights. Don't forget to subscribe to the channel and click the bell for notifications. I hope you'll join us again next time.